Welcome everyone to the fifth of our Mining Insight webinars. Thank you for joining us again. This session is covering restructuring issues in the mining sector. For those of you that may have missed our previous events, they're all logged on our website under our mining section, and we've covered topics such as ESG and compliance issues. And next week we'll be looking at Chinese investment into the mining sector. But today, as I mentioned, we're going to be talking about restructuring in the mining sector. My name is Rachel Spate and I'm one of the partners in our mining group. And today I'm joined by Amy Jacks and Devi Shah, who are partners in our restructuring team with experience of a wide variety of sectors in the restructuring area, but they've both dealt with mining issues. They're going to talk to us today setting the scene about the big picture about what's going on in restructuring, given the current issues with COVID-19, and then looking at particular restructuring issues relevant to financing in the mining sector and issues relevant to particular jurisdictions and contractual relationships. We hope this is a practical guide to the issues that you will need to consider when a project or a company may be in a bit of distress. I'm going to hand over to Amy, who's going to give us a general overview of the mining sector and some of the restructuring issues. Amy.
Thanks, Rachel. So I think if you look at the mining industry as a whole, the top mining companies are actually in pretty good financial health, notwithstanding the current COVID crisis. And in fact, mining as an industry is faring better than many other sectors. And there are probably a number of reasons for this, but many mining companies did a lot of cost cutting after the 2008 financial crisis, and so they're in better shape than they maybe would have been. And certainly the larger companies have gone into this situation with strong balance sheets. I think also the industry is used to weathering fluctuating commodity prices and obviously reacting to the big macro issues like the environmental developments over recent years and the move from fossil fuels to green energy. So the industry is arguably more adaptive than certain others. And then when we move into the current COVID-19 situation, mining as an essential business has actually been allowed to continue to operate through lockdown, meaning that unlike various other industries which have been hit really hard and very quickly, so if you look at aviation or the travel industry, actually many mining businesses have continued broadly as normal. Sticking with the positives of where we currently are, notwithstanding the fact that, of course, there has been a drop in customer demand and therefore prices on certain commodities, actually many governments around the world, including our own, are very, very focused on infrastructure and building projects in order to inject the desperately needed impetus into the economy. And as such, many commodities, things like iron ore, will be in high demand in order to supply these various initiatives. Having said all of those positives, of course, this economic cycle and where we're going into post this COVID-19 pandemic has, of course, had an impact on the industry. And the current economic challenges will, of course, hit certain businesses harder than others, depending on their particular circumstances. There's the practical impact of the travel bans and the local lockdown restrictions. And in certain of the world's more remote mines, I guess as long as there obviously aren't cases in those individual mines, the workforce in effect and therefore be able to just continue as previously. But in other situations, they're obviously a hotspot for infection because you can have a very large labour force, maybe working underground or in otherwise cramped spaces. And we have seen closures in recent weeks and months, whether in the more general sense in places like Peru, where the state have closed things down in order to control the pandemic, or in specific situations where there've been localized outbreaks, such as the coal mines in Poland. On the health and safety front, of course, that is something that's very much at the forefront of this industry, and therefore, again, adaptation has probably come more naturally to many mining businesses than in certain other sectors, as they've had to move to adapt to the various challenges that they're facing as a result of the pandemic. So I think, Rachel, in summary, there are lots of positives, but of course that doesn't mean that the industry will not be without some distress. And companies are going to need to adapt and embrace change, some of which might actually be better in the long run, such as increasing the use of automation. And then even those I mentioned at the beginning, the top mining companies who have gone into this with very strong balance sheets and very healthy in themselves, they're still likely to encounter issues within their supply chain, for example, which I think we'll touch upon later. And there's a lot of money out there to be put to work, but of course mining is a very specialist sector and tends to have investors and lenders who understand the industry. So I'm going to hand over to Debbie now, because I think she will talk a little around the stakeholders involved and the sort of structures and issues that one sees when restructuring in the mining context.
Thanks, Amy. Well, Amy, as you and Rachel will know, one of the first matters which advisors have to get to grips with are who are the stakeholders and what interests do they have. This involves understanding not only who the players are, but what rights they have in relation to which part of the corporate structure. And a typical corporate structure in a mining scenario will include some or all of the following. First, you may have a parent company established in a key financial centre for raising finance for the mining industry, such as the UK, US, Canada, Australia, Hong Kong or South Africa. That parent company may have issued bonds, it may be listed, and it may have provided one or more guarantees in relation to the project finance. Sitting then immediately below that parent in the corporate structure, there may well be an intermediate holding company in a favourable offshore jurisdiction for tax. The offshore intermediate holdco will be the sole or main shareholder then in the project co or opco, which is likely to be incorporated in the home jurisdiction where the mine is. The opco is likely to be party to a multitude of credit arrangements. Its key finance line may come from a group of lenders, including commercial banks, development banks, export credit agencies, and private equity investors and other funds, who may benefit from a comprehensive security package, including share pledges across the group. Whether this security package will include security over the key license or concession will depend on the local law on this point, and it may well not. In addition, the OPCO, as well as having equipment finance and other bespoke agreements with its suppliers, may have streaming or offtake contracts in place with purchasers. The OPCO will also be party to the critical contracts in the mining project or operation, including the license from the host government and supply contracts. And you can already see from this that in a distress scenario, you're likely to have a significant number of stakeholders who will have different priorities and interests, and therefore whose commercial drivers may differ. In addition, the stakeholders may themselves have multiple interests at different levels in the structure. The same party may, for example, be a bondholder, a hedge counterparty who might be in or out of the money, and also lenders at the OPCO level. Just taking a couple of examples of how this may affect the situation, you may have off-takers and streamers who are only unsecured creditors of the OPCO, and their interest will be in seeing the OPCO continuing to run the mine, potentially with additional credit lines and or new owners, but high above at the parent level, but otherwise not significantly altered. If there is a sale of the mine through an insolvency process at the OPCO level, they risk losing out. At the other end of the spectrum, you may have bondholders that are holding notes issued at the parent level, but who have no recourse to the OPCO, and they risk losing everything if there's a restructuring which involves the sale of the group lower down the structure, for example by the intermediate holdco or indeed of the business of the OPCO itself. Steering a disparate group of stakeholders towards a restructuring deal is likely to be challenging. In most restructuring scenarios, advisors will always emphasize that the earlier the parties engage, the better the outcome is likely to be. But in a mining business, for reasons we'll come on to develop, this will be all the more so. Key lenders may have entered into an intercreditor agreement. These agreements can become extremely complicated in situations like this. In particular, where as the project develops and comes on stream, stakeholders may come in and out of the process, leading to the intercreditor arrangements being amended on multiple occasions. Difficult questions of interpretation may arise, and the key points you have to consider include matters such as the voting thresholds for consents for waivers and standstills, as well as for instructing any security agent to take enforcement steps. Even where there is an intercreditor agreement in place, questions will arise as to the enforceability of its provisions because of the complex cross-border nature of the typical group structures in place. And I think, Amy, that's something you've been giving thought to.
Yes, thanks, Debbie. And so Debbie's mentioned when talking about the various finance structures that the ownership and operational structures in mining groups tend to be cross-border, with parent companies, maybe listed in London, Toronto, elsewhere, a holdco in an offshore jurisdiction, and then the operating company normally where the mine itself sits. And there are various implications to this when you're looking at financing or indeed restructuring these businesses, because the different arrangements, whether we're talking about the financial structures or across the matrix of contracts that will be in place, this can lead to various conflict of law issues, and it's therefore imperative that you seek local law advice. From a practical perspective, the political impact around the jurisdiction of the operating company also needs to be taken into account, and engagement with local officials is going to be critical, and in many cases you're going to need not only the local legal advice, but also the right people on the ground who have got the right relationships to help assist you with those negotiations. There's likely to be an ability to block a change of control, or maybe it'll be that consent is required in order to transfer any licenses. But really, regardless of the strict interpretation of the legalities, it's also going to be essential in such jurisdictions that the relationship with ministerial officials is developed. And certainly if there's going to be a sale of the business, you're going to need cooperation in order to have support of any new owners for the business then to thrive moving forward. Timing is also something that should be taken into account. So, for example, if you have upcoming elections in the relevant country, consideration should be given to the impact if there were to be a governmental change, and then the potential changes that might come about with regard to, for example, taxation subsequent to that governmental change, because of course those things might have a significant impact on the outcome of any proposed restructuring. One further thing just to think about on the jurisdictional front is the local laws around directors and directors' duties, and the risk of any actions by the lenders resulting in a challenge that they've acted somehow as shadow directors with the associated liability that might go with that. This isn't something at all specific to mining, and in fact in this jurisdiction, a lender who's relying on their contractual rights within their finance arrangements, so for example, increased information provision or tighter controls around cash flow or bank accounts that you might normally see when there's any default or distress element to the situation. These things wouldn't normally lead to any challenge around the lenders being shadow directors and consequently in any way liable. However, of course, in a cross-border situation, that's common in mining, it would be very prudent for lenders to make sure they're not putting themselves at any risk across the different jurisdictions and making sure they get that local law advice. And also, of course, at the board level of the various companies, you might have a situation where particular individuals are sitting on more than one board. Sometimes they might be boards in different companies, but also in different countries. And there's an added layer of complexity there because you need to ensure that you're wearing the right hat and taking the right action for the benefit of the particular company, but also remaining compliant with the relevant local laws that apply, so rather than taking a blanket group approach. So I've gone through some of those issues, Debbie. I think you're going to now talk in some more detail about the licensing and other contractual issues that I've just touched upon.
Yeah, absolutely. Thank you. So in addition to understanding the financing matrix and the jurisdictional issues, it's important to appreciate the complex web of contract licenses and obligations to which the OPCO is subject. Fundamentally, to preserve or extract value from the group in a restructuring or on a distress sale, you're going to need to keep the key arrangements in place and find a way to manage the risks and obligations which are a particular feature of mining businesses. At the heart of such a business will be the licenses or concessions granted by the relevant ministerial body. Because of the risk Amy identified of the licenses being terminable on insolvency, the usual protections which the group might reach for where it has a cash crunch and just needs a breathing space to put together a restructuring deal, such as filing for protection from creditors under the umbrella of an insolvency process, may not be practical, and a consensual standstill period may need to be agreed. While some jurisdictions, including now the UK, have included within their insolvency law provisions restricting termination of contracts triggered by insolvency, the important question may well be what the local law provides. In countries with less developed rescue regimes, these protections may not be in place, so precipitate action may therefore lead to a catastrophic loss in value. So the group working with its stakeholders is likely to need to keep operations ongoing, at least at the care and maintenance level, while a restructuring plan or sale is being explored and implemented. This means that it's critical to keep key suppliers and service providers in place, supporting the operations. Not only does this mean in turn that the group will need a source of liquidity, but also that in order to deliver the sale of the business and operations, a purchaser needs to be assured that appropriate consents to assignment of contracts will be forthcoming. Early and careful engagement with contract counterparties and authorities is therefore essential. Significant obligations will attach to licenses and concessions, including in relation to decommissioning and environmental and social responsibility. Lenders and other stakeholders are going to be particularly concerned that whilst they need to drive a restructuring, provide liquidity to enable the operations to continue safely and steer the group towards a solution, they will also need to ensure that the solution they are working towards adequately addresses all of the potential pitfalls and doesn't leave them exposed to liability. From the standpoint of the authorities in the host country, they're going to be looking to ensure continuity of operations. And if the current owners are financially distressed and don't have the support of their lenders in the long term, they will want to see an orderly transition to a new owner with the operational track record and financial wherewithal to comply with the myriad of health and safety, environment and social obligations which are associated with these enterprises. The very significant decommissioning and environmental liabilities mean that debt for equity swaps, a common solution in distressed situations, are much less attractive or common, as lenders don't want to end up owning the mining assets. Where a company's financial difficulties cannot be resolved consensually through amendment and extension of the existing agreements or the introduction of new money on a consensual basis, then a controlled sale process may be the most attractive option. Given the complexity of the operations on the ground and the risks involved, it's easy to think that pre-packaged sales might be an important tool here. They have, for example, been successfully used in the restructuring of operating companies in the North Sea oil sector. Amy, do you think they might work here, and what are the relevant issues?
Well, there are certainly some challenges around the enforcement and pre-pack route. I think possibly it's worth just pausing for a moment to cover off what a pre-pack actually is. It's a process that we often use here in the UK. It's also very common in the US and is used in other places. And the idea is that an insolvency practitioner is lined up and works with the company on the run-up to an insolvency and finds a purchase of the business and actually agrees the entire sale arrangements prior to being put into position. The IP is then appointed, and immediately afterwards the sale agreement is entered into, the idea being really to minimise disruption to the business and to retain value. From a legal perspective, you're going to need to ascertain whether the process is actually available in the relevant jurisdiction. So firstly, considering which jurisdiction the insolvency process will be undertaken, and is a pre-pack available as a mechanism within that jurisdiction. Even if it is available, there are various hurdles to overcome which may make this route a non-starter. So, for example, if you're looking to sell the OpCo business or parts of it, the license is, as Debbie said, may be terminated or terminable on insolvency. So it would therefore be imperative to make sure you have the licensor on board and you know that they will actually refrain from terminating and are on board with facilitating the proposed sale. It may, for various reasons around the complexity of the contractual structures, be preferable to try and keep the operating company whole and avoid those problems and the impact that you might have by an insolvency at that level. And therefore, you might look to do enforcement higher up the chain at parent co or hold co level, and then transfer the shares by the insolvency practitioner to a purchaser. So you'd sell the opco itself. However, in order to achieve this, you'd still need to do the necessary work and make sure that that process or the transfer of shares itself can actually be done, whether you need consent or whether there's any change of control, prohibitions, etc. The licenses and the contract would also need to be reviewed to ascertain whether an enforcement and a sale even higher up the chain would nevertheless allow counterparties to terminate at the operating company level. So then, assuming you do find an appropriate pathway through to take such enforcement action at whichever level we're talking about, the insolvency practitioner who's going to take the role will also then need to get themselves comfortable in doing that. So are they comfortable with the liability risk? Obviously, health and safety and environmental issues are serious concerns for ISPs, and many mining projects, of course, fall into Category A of the World Bank standards as projects that are likely to have significant adverse environmental impacts. So the insolvency practitioner will want to consider and understand those risks. How have they been dealt with historically? Can they manage them moving forward? They'll also want to think about whether there's any decommissioning involved and what would the risks be around this. And going back to my earlier point on local law advice being so critical, they're going to want to make sure that all of these sensitive and high-risk areas, that they're very clear on the local obligations and that they're comfortable that they're going to be able to comply with those obligations. It might actually be, as is quite common when there are high risks around things like environmental, that the insolvency practitioner actually turns to the lenders to provide them with an indemnity so that they can mitigate, the insolvency practitioner himself or herself can mitigate this risk. But of course, that just in turn pushes the liability onto the lenders, who would also then want to have a clear understanding and therefore be able to quantify the risk as best they can. So I think in summary, a pre-pack might be an option. It's a very effective option in many scenarios, but a lot of preparatory work would need to be undertaken. And the timings to achieve the various consents might actually mean it's not in practice a viable option, and so alternative restructuring tools may well need to be considered.
Thanks, Amy. So if you can't do a pre-pack, ideally you are looking to resolve the issues faced consensually through a combination of the key lenders providing additional facility, relaxing covenants and extending maturities, and if you've got bondholders, them engaging in consent solicitations or exchange offers to restructure the terms of the group's notes. Where there's appetite to support the group with those kinds of measures, but not all of the stakeholders are willing or indeed able to consent to the proposal, it may be necessary to push the restructuring through using tools such as schemes of arrangement or restructuring plans. In the UK, there are now two options available, including to companies incorporated outside of the UK, as long as they can demonstrate, for example, that they have assets in the UK or liabilities governed by English law which they're seeking to restructure. These are compromises or arrangements set out in a proposal document which is subject to creditor and court approval. They can facilitate the amendments of notes and facilities and extension of maturities where voting thresholds under the terms of those documents can't be reached, but where at least 75% by value of the relevant stakeholders do support the restructuring. In other jurisdictions such as the US, that threshold for approval may be significantly lower than 75%. In the UK, new reforms have also included the possibility of a proposal binding stakeholders where they are approved by some classes of creditors but not others, known as cross-class cram-down, which is another interesting tool to be thrown into the mix. Rachel, did you want to pick up on some closing thoughts?
Yes, just to summarise there, thank you both for that. Just to summarise some of the topics that you've covered, when we're looking at the supply chain, what are some of the key issues that businesses should be looking out for?
Rachel, supply chain risk and management of that is always a critical issue for all businesses. And of course, the impact of problems in the supply chain and the potential failures therein are obviously going to be exacerbated by the COVID pandemic. So I think it is something people should be, in all businesses, very cognizant of. There are certain practical ways to mitigate the risk of failure within your supply chain. So For example, whilst it's clearly quite a painful administrative task and time consuming, undertaking a regular audit of your contractual arrangements with suppliers is actually time and money very well spent. It also gives you the opportunity to pause and actually consider what your contingency planning might look like. So have you spread the risk as best you can? Sometimes, of course, it's not possible, but just consider that. Have you looked at alternatives? Do you know what your rights are in the event of a supplier failing or just not performing? Because often what happens from an insolvency perspective in these sort of circumstances is speed is really critical. And ideally, you want to be ready to act swiftly rather than finding out about a problem and then spending a few days while you try to locate your contracts and get someone to review them and work out what your options. So being on top of it is really worthwhile time spent. And I think one of the other interesting outcomes of the COVID pandemic, again, across all industries, will be that people will reassess the sort of globalization concept and the idea of global supply chains. Of course, in many ways, this has been very much for the good, and sometimes it's just an absolute necessity. But I think it would be prudent to consider whether certain of your supply chain and counterparty engagement could actually be undertaken more locally. And in fact, we have recently seen several of the larger mining companies have been announcing initiatives to do just this and increase their support also then within the local communities in which they operate. So, I think taking your time now, while you have potentially the time before, all economists think the economies are going to worsen. So use this time to get your ducks in a row so that you are in the best possible position if things do go wrong within the supply chain.
Thank you. That's really helpful. And Devi, just secondly, what should a company be thinking about if they are suffering some financial difficulties?
I think it's really about, pulling all those strands together and picking up on Amy's theme. Taking action early is key. That means being on the front foot, making sure that you are informed so you know what potential covenant breaches or liquidity crunch or other issues are coming down the track, that you've worked up a proposal for dealing with these issues, and you know what your ask is from your stakeholders, and you've engaged with those key suppliers and the authorities, and you've got them on board, and you've done the homework to get them and the financial stakeholders comfortable with the plan, which may involve working with financial and other advisors and preparing evidence such as detailed cash flow forecast to support your proposal and bring them on board.
Thank you, Amy and Devi. That was a really interesting overview of some of the key issues to think about in a restructuring. To our listeners, we hope you found this a useful session. We hope you'll join us for future sessions. And if you have any feedback, please get in touch. We'd love to hear from you if you've got some ideas for future sessions. So thank you very much for your time, and we hope to be in touch and see you very soon.